Truthfully, I've been wanting to see the contract between Lively and It Ends With Us LLC for a long time. And so let's go through it. As recently as July 31st, 2025, when Lively filed her second amended complaint, she alleges that at all times she was an employee under Title VII of Wayfarer and It Ends With Us LLC. But this agreement begs to differ. Now, typically, an agreement like this is a strong indication that someone is a contractor, an independent contractor that is entering into a business relationship with another entity. So here it would be Blakel Inc. loaning out the services of their employee, the contractor, Blake Lively, the actress, to the entity It Ends With Us LLC to provide acting services to It Ends With Us LLC. Now, this is where it gets very hairy, and this is where there's a lot of complicated analysis that takes place. Under the Fair Employment Housing Act in California, the inquiry that a court would make when determining whether or not someone that is being loaned out in a loan agreement like this is an independent contractor or not is who actually controlled, supervised, or directed the work. Was it the company, the studio productions decisions, or did the actress have independence and ability to control their work? This is where Lively's own actions are going to go against her for a determination of employee status, because there's allegations that she sought control of the film, control of her wardrobe, control of her makeup, control of the time in which she was able to act, control of the scenes, control of the script. All of that cuts against an analysis that someone is an employee. Now, put a pin in that because that matters when we get to federal statutes, Title VII. But under FEHA, contractors have protection under the anti-harassment, anti-discrimination, anti-retaliation laws. So even if she is considered to be an independent contractor, she can bring claims under FEHA for retaliation or harassment, which she has done here. Where she may go wrong is that Title VII, the federal law of anti-harassment, anti-retaliation, anti-discrimination, does not cover independent contractors. So her claims, based off of the facts presented here in this document and what we believe to be true from what we've learned through the case, is that she did exert a lot of control, so she could not be considered an employee of It Ends With Us or Wayfarer. So under federal law, they would look at a number of factors, including control, integration, economic realities, the duration of the agreement, whether there's a contract like this, to determine the relationship, whether it was an employee relationship or an independent contractor relationship. And my guess is that Lively didn't include this contract, didn't attach it to any of her complaints, including her most recent amended complaint, because it cuts against the presumption that she's an employee. She alleges that she was an employee, but this cuts against it. By her very own admissions, she had a lot of say in what happened in the movie, so much say that it earned her the coveted PGA mark, executive director mark, or whatever it is. In order to get that, you have to show a certain element of control in the outcome of the movie, with respect to the wardrobe, with respect to the script, all the stuff that I just said. So that is going to be a really difficult thing to overcome when faced with the argument that you're not even an employee for purposes of Title VII. So to recap, this hurts her federal claims, but doesn't necessarily hurt her California claims, because California law extends that particular coverage with respect to harassment and retaliation to contractors in most cases. Now, a lot of people have pointed out that she didn't actually sign her agreement. That doesn't kill the agreement. If you act as though the agreement was binding, then essentially a court can deem that it is binding on you. You don't actually have to have a wet signature on it. It helps. It certainly is important. It certainly is curious why she didn't sign it, but that doesn't necessarily void the contract completely. Now, something else that I find interesting is that it says it right here in the contract that the location of all of the activity that, as far as It Ends With Us LLC was concerned, they would get from Lively for this role, it would be in New Jersey and Las Vegas, and that's it. It doesn't say California. It doesn't have any ties to California. It says that's where this is going to take place. And later down in the agreement, it says, for tax purposes, you need to be registered in those states or in New Jersey. So this is going to be an important point to bring up in a motion for summary judgment. Here is further evidence that she was not exerting herself in California. She was working outside of the state. Even the agreement conceived of her only working outside of the state. So why does California law apply? In fact, the agreement goes on later to talk about if travel is necessary to New Jersey or if travel is necessary to Las Vegas, how they would make arrangements for that, what kind of stipend would be created or provided for that travel to those specific locations. There is nothing nada about doing any work in California. So even though California law would apply to independent contractors, California law does not apply to contractors that are not working in the state. It would be as if one of the plumbers that goes into one of your offices in Ohio sues you in California or under California law. It doesn't make sense. Why would a plumber doing work in Ohio, an Ohio contractor doing work in Ohio, why would an Ohio contractor be protected under California law? Hence the extraterritoriality agreement that we saw by the Wayfarer parties in the MJOP. Now, they're going to be able to hit this point a lot harder with evidence. They will be able to include this as an exhibit to their motion for summary judgment. At the MJOP stage, remember, it was limited to only what the pleadings said. So they couldn't draw from pieces of evidence like this to support their claims. But now they can. When they file their motion for summary judgment, they're going to pour all the evidence they have. The work was done outside of California. It was all intended to be outside of California. She never stepped foot in California with respect to this movie. Allegedly, I don't know, maybe she did, I just don't know about that. But if that's true, that's the evidence that the Wayfarer parties are going to put up in their motion for summary judgment, and that's what's going to get weighed by the judge. I find this provision kind of interesting and curious because it basically lays out that the artist, Lively, is not permitted to share things about the movie that are outside of the public domain. They can't go to the tabloids, they can't take B-rolls of what's been going on set. They can't show things about the movie outside of what's approved by the production. And I explicitly remember an interview or a clip about Lively showing a cut of the movie to Book Bonanza without permission. At least that's what she presented to the audience, that she was going to show an unedited cut of the movie without permission. So that's curious. It seems to me that in and of itself is a technical breach of this agreement. In the standard terms section of agreement, there's a provision about sexual harassment, and there's a provision about arbitration. Basically, it says we will not tolerate sexual harassment that can destroy the contract. It also says in the arbitration provision, any issues that arise out of this contract between these two parties should be arbitrated. Now, technically, Lively has claims arising out of this contract, or arising out of the agreement between the two parties, arising out of her work on the set of It Ends With Us. Now, as of 2022, under federal law, it is prohibited to mandate arbitration for sexual assault and sexual harassment claims. So despite the fact that an employee might have an arbitration agreement that would encompass SH claims, the law says that you have the option to arbitrate those claims or seek those claims out in court. And there is case law in California, recent case law, that says a plaintiff's entire case, meaning other claims included, would be exempt from the Federal Arbitration Act when there is a sexual harassment claim. So here the arbitration provision is sort of defunct because Lively has a sexual harassment claim. Therefore, her entire case, her entire claim, all of her claims could be exempt from the arbitration agreement. It seems like federal courts would follow the same kind of logic. In any case, it doesn't look like the Wayfarer parties are compelling arbitration in this case, or else we would have seen that really, really early on in the case. There would have been a motion to compel arbitration. So they didn't do that here. They chose not to do that. It makes sense because forcing arbitration would put this all on a pause until that's resolved. Fights would be had about that, and then ultimately it would go into a private arbitration. And so they must have made a calculated decision that it was not in their best interest to do that. Anyway, the other part of the agreement that I thought was interesting was the award bonuses section, which essentially talks about if Lively were to be nominated for an Academy Award for Best Actress, that she would be entitled to an award by It Ends With Us of $100,000, and it goes on to name a couple of different nominations and awards and the amounts that she would get in those instances. Now, I don't know enough about these agreements to know whether or not this is standard. Alicia, if you're watching, I'm curious what your thoughts are on this, or anyone that works in the industry that sees these agreements, because this struck me as very interesting. This has been a long-winded overview of the contract and parts of it. I obviously didn't go through every single page. There's 35 pages. If you have any specific questions, if you've read the document, you have specific questions, or if I wasn't clear, please let me know.